suspects and their counsel in court, and this is just a matter for directions as to modalities for taking plea, or in view of those who are absent today. We'll be praying for summons. Except for Lina Kugei, who is represented, and there's a reasonable explanation for her absence. That's from the prosecution side.
The view that tomorrow, that this week might be too near. This week might be too near. Too near, too soon. I propose a month at the very least. I know my colleagues will be addressing you on a matter related to what I've said.
So file an anticipatory application, that is number E325 of 2022, which is also slated for hearing tomorrow. Besides that, Your Lordship, there is also a constitutional petition that had been filed, which we had also made an application for enjoining. That was the E499 of 2022, which I understand that your sister, Lady Justice Ongudi, referred it to Criminal Division. And my colleague, Mr. Nzak, will be addressing it. But basically, before that, also one of the things that we will be seeking for determination is the jurisdiction of this court. To handle this matter. The DPP, in his letter of 28th October 2022, acknowledged that this is the first matter happening in this country. Being that, Your Lordship, this is a special matter that should be handled by a special court, given that it originates from the Rome Statute, which is domesticated by Article 2(5), and the International Crimes Act. Your Lordship, on that one, we would like the determination on whether this court is the right court to hear that matter. Article 162 that creates some special courts which it has created their state categorically granting jurisdictions to those courts. And judges of those special courts are gazetted by the Chief Justice. So we will also be seeking the determination of that matter in this court. And also we'll be seeking to determine the selectiveness of, but that one I'll not want to address it because it is in the petition, Your Lordship. So for that one, I'll be requesting that you suspend this plea taking because we have raised all these matters that touches on constitutional rights of the suspects and the constitutionality of the matter before you, Your Lordship, and the jurisdiction to handle this matter, and not the ICC or a special tribunal to handle these international crimes. I request that this matter be in abeyance as we hear other matters before this honorable court, Your Lordship. Thank you.
So, Lord, on behalf of Cyprian Roby, the 8th suspect,
jurisdiction of this court, and therefore, my Lord, we do pray that the plea taking be put in abeyance before the determination of those preliminary issues.
Number E499 of 2022. I have had the privilege to peruse the application and the petition therein. I feel that my clients would want to be part of the petition and the determination thereof of that petition. I believe that the petition raises weighty issues that have been put before you by learned counsel for the second accused person. And so I do join issue with my colleagues, advocates for the accused, for the suspects, that the plea taking be halted until the constitutional petition is heard and determined. I believe, my Lord, that this is a matter that has been in court for the past 5 years, and suspending the same for 1 or 2 months will not be prejudicial to the victims or any party involved thereof. On the part of the 4th accused person who is absent, and even if the matter was to come before you tomorrow, Your Honor, my client Lina Kogei would not be able to avail herself because she's been indisposed and was admitted for a week. She's just been discharged from hospital, and she's been recommended for a bed rest for a week, which is 7 days from now. I believe that the 1 day request by the DPP will not be sufficient for my client to avail herself. For that reason, Your Honor, I plead that the plea taking be put on hold until such time when the constitutional petition is heard and determined. Thank you, Your Honor.
I wish to associate myself very strongly with the submissions by Mr. Munoko for the second accused. The point we are taking, my Lord, is that jurisdiction in law is everything. It is, in our view, a preliminary issue that this court must address first, even before plea. Because if, Your Lordship, you come to the conclusion that you have no jurisdiction, then you will have no business but to terminate the case in limine. My invitation, therefore, is that this jurisdictional question be determined first, before plea. And therefore, on behalf of my client, we will be applying to join the constitutional petition, which will address all these preliminary issues of law. We therefore pray for time, that the plea be deferred to another date to exhaust the filings before the Constitutional Division. And, my Lord, therefore, on behalf of my client, I'll be requesting for the plea be deferred for 2 months I believe that way these preliminary issues of law will have been addressed sufficiently. I think that will be it for now. The suspect enjoys all the rights. My lord, you can, to take care of that, you can extend the summons. They are on summons. Summons can be extended for another 2 months. No prejudice will be suffered by any party, be it the victim or the prosecution. That will be all on our part.
The same is today for hearing before your brother, Justice Bononga. The three, my lord, didn't file a constitutional petition. This petition is due for hearing in the parties tomorrow. The petition indeed goes to the root of this information from presented before court. Its constitutionality, and it can only be fair enough if room is given first for the constitutional petition to be heard and determined. That is being constitutional petition E499 of 2022. The matters the petition arises, actually, they go to the root of this particular information, and I do not want to be seen like presenting too much information to the court. The aspect, the principle of self-incrimination is guarded in our law. And just in a snapshot, what we are saying that this information presented before court, it's based on an inquest where majority of suspects, without being cautioned, they might have incriminated themselves. And we'll be asking ourselves whether that evidence would be the right evidence to be relied in this particular trial. Additionally, just a note, you will find that the DPP, in fact, participated in the inquest. We will be asking our question when we reach there, whether the DPP is a right party to participate in an inquest, where ultimately the inquest witnesses may be found culpable for prosecution. Associating myself with my colleagues and considering that the constitutional petition is coming up tomorrow, we can get a mentioned date for this matter, so that this court can be informed of the progress of the constitutional petition. Probably I'll also be praying that if we get a mentioned date, as we put the taking of plea in abeyance, and on the basis that we'll be taking a mentioned date, I'll be praying the court with a common day set that the accused person be presence be dispensed with on the mentioned date. Thus, they've come to court by own pollution. They still remain officers and government employees. We have no qualms that they may disappear. That's all, my lord.
The questions on jurisdiction and or competence of this court to handle the charges before you, and the constitutionality of the intended or impending proceedings before this court. And my lord, further to that, the need to allow the suspects to exhaust the already initiated alternative or administrative processes, including the pending court actions that have a direct bearing on the matter that places us before this court today. On behalf of the 8th suspect, Lord, we have filed for review of the decision of the DPP to charge. The same has been done both with the DPP and IPOA and are pending. It would therefore be fair that the 8th suspect, as the other suspects in other proceedings, be allowed to exhaust that. In that regard, therefore, we request that these proceedings be held in abeyance, preferably for a minimum of 2 months. I believe, my Lord, within that time, number of these pending actions or processes we will have determined, so that there will be clarity on which direction we take moving forward. We could therefore have a mention of the matter, my suggestion, in 2 months' time.
Capture what it has also been submitted to you that this case has been in court for 5 years. Your Lordship, we actually oppose that sentiment, and we state that the victim will be prejudiced by any further delay in this case. The victim has been in court for 5 years, and at this juncture, this will be tantamount to denying the victim his rights. His fundamental right to justice, Your Lordship. It has also been argued, or it has been submitted to you, Your Lordship, that the accused are here on summons. We differ with this submission, Your Lordship. The accused are suspects who have been brought to you and have been suspected of committing grievous crimes. They are not here on summons. They are here as part of the court process, and they have been brought in custody of the investigating agency. Your Lordship, it has been submitted to you that this is a novel issue. And while we agree that this is a novel issue, before you, we submit that you cannot ignore the law, especially as pertains to the criminal law in this country. It has been submitted that that some of the accused persons have applied for anticipatory bail. Your Lordship, this is not a bar to them taking plea before you. In fact, it sounds to be like they are ready to take bail, to take bail, which means they're also ready to take plea. So if they're willing to take anticipatory bail, they cannot be stopped from saying they cannot take bail before you, Your Lordship. It has also been argued that there's a constitutional case that has been filed. And it has been argued that you should stay this matter until the time that the other matter is heard. Your Lordship, the Constitutional Court is a high court, according to the hierarchy of courts. Just like this criminal court is a high court. I have not heard of any petition before an appellate court or a court superior to this court. No order has been served to this court ordering a stay of execution of this taking of plea. And rightly by law, the accused should take plea in absence of such orders. Your Lordship, it has also been argued that you do not have jurisdiction. We submit that this argument has been prematurely brought before you. And the proper course of action should be the accused to take plea and then raise the issue of jurisdiction via an application or a preliminary objection. This, Your Lordship, has not been done. We are submitting that you should allow or invite the accused persons to take plea. Then they can raise their misapprehensions. If they have any, for your consideration. Should they have a problem with your ruling, Your Lordship, they have the recourse to appeal that ruling by law. This has not been done. We also submit that in the absence of the accused persons taking plea, since they are before this court has the power to remand them in custody until the time they are ready to take plea, Because if they have been granted any police bail, which we seriously doubt they have, that particular bail expires once they have been brought before your lordship. So in absence of any orders of the court, allowing them to be free, we submit that they should be in custody until they do take plea. This is our criminal justice system, and that is what the criminal law says. Finally, Your Lordship, I humbly beseech you to uphold the victim's rights as regards the non-taking of plea. We pray that the accused persons be invited to take plea. That is all, Your Lordship.
Very quickly, my lord. If that approach were to be adopted in our criminal justice system, my lord, I assure you no case will ever be proceed in this court. All accused persons will be filing references, will be writing applications for review, and pleas will be deferred indefinitely. They can even go further and tell you, if they lose in those cases, we filed an appeal before the Court of Appeal. And nothing will ever move. At this point, what we invite the Honorable Court is to allow the criminal trial process to commence by plea taking. All the other points, my lords, speak to the defenses they are going to raise. We'll respond to them when the time comes. This is plea. This is not the trial. And they're telling the Honorable Court, let's suspend that trial commencement indefinitely. My lord, baby Pendo will have been probably 5 years today. She doesn't exist. Her soul is crying for justice. Let her, even as she rests in peace, know that she left behind a country that cares for other baby Pendos by giving her an opportunity for her trial to commence. Otherwise, it won't be worth it. And lastly, my lord, all the issues being raised by the defense counsels, the proposed defense counsels, they can raise them in formal applications where we can substantively respond to them upon plea taking when the criminal trial process has commenced. And parties will have a substantive opportunity to respond to each and every of those issues. I do pray, my lord, that you allow the criminal trial process to commence and give us the earliest available date. The prosecution has indicated they are willing to come back even tomorrow when we ask for that.
The Kenya National Commission does protect and promote fundamental human rights, both of the accused and of the victims. Your Lordship, I would join issue with my colleagues and state that the victims have been waiting for this opportunity for 5 years. Listening to all that we've been told, that this court has been told, they seem to have filed applications relating to non-existent proceedings. The issue of jurisdiction, it must relate to existing proceedings. proceedings that are already commenced and which exist, and then the court can be urged on issues of jurisdiction. As my learned friend has also said, there is no stay anywhere. And this court is as high a court as the Constitutional Court. Your Lordship, there is absolutely no reason why the victims should be waiting ad infinitum et tuo. It is necessary for this court to begin the process. And I think the prosecutor brought the case to court in its fullness, so that proceedings may commence. And once they have commenced, then there will be a forum to canvass all those applications, and I dare say any devices to delay the trial. There will be a proper, convened and constituted forum to argue. But before the plea has been taken, we are talking about non-existent proceedings. That is not known to our criminal law. I urge Your Lordship, together with my colleagues, to commence the proceedings and let the rest follow. That is all.
Counsel before you to support that prayer. My Lord, indeed, IPOA is a party to various applications filed by defense counsel, but in none of those applications has the courts deemed it fit to stay these proceedings. My Lord, the proper procedure would be for the parties to argue, my Lord, that prayer in those applications. My Lord, no single application, my Lord, in respect of this matter was filed before you. My Lord, the defense knew over 2 weeks ago they were coming before you today for plea taking. They did not file a single formal application before you to stop plea taking. My Lord, it's therefore an abuse of the court process for the defense counsel to try, my Lord, to short-circuit the system by seeking to be granted prayers in these proceedings with regard to other proceedings that they have filed, my Lord. I would therefore urge you, my Lord, not to allow that prayer that is unknown in law, and my Lord, we are ready to proceed with plea taking. Thank you, my Lord.
The miscellaneous application that was filed 3/24/22 before Justice Bononga has been referred to this court. So Justice Bononga has declined to deal with it, and that means that this is the right court to deal with it. Another application transferred on the application of both parties, plea in this matter, so that all these arguments that are canvassed can be canvassed in the right forum. Our concern as the prosecution was to ascertain the presence of the suspects in court, and also to seek for the availability in the event a plea is not taken today or at the earliest opportunity, so that, again, we also wanted to know who is represented and who is not, and as we take cognizance of the seriousness of the matter before the court, and for that, and there has been no intention to arrest any party as long as they are available, they are willing to avail themselves before the court as and when the need arises. But at the same time, taking cognizance of the seriousness of the matter, we would like the court to give some stringent measures so that we are sure, we are certain that these parties will appear in court, not only for plea, but also for the next mention and the trial. That is what I can say for now.
So that subjects who are not present before the court can attend. The defense side have sought for deferment for at least 2 months so that they could pursue the constitutional petitions that they intend to raise on the issue of jurisdiction of this court to hear this matter. I am of the view that even if plea is taken, the subjects will still be at liberty and will reserve their rights to pursue the intended constitutional petitions, which, if successful, could still even lead to orders that could declare the proceedings herein a nullity. So in that event, I do not see any prejudice that the subjects would suffer should plea be taken at this stage. This court has been told that this matter has been in the courts for about 5 years. In balancing the constitutional rights of the subjects before the court and those of the victims, it is my view that it is proper and fair that plea be taken so that this matter may be determined one way or the other. It is in the interests of both sides, therefore, that the subjects do take plea hearing and to respond to the charges as urged by the prosecution and supported by counsel watching brief for the victims. In the circumstances, therefore, I am making the following orders. Number 1, that the plea hearing be deferred for 7 days to enable the subjects who are absent today to be present with their advocates. Number 2, that summons will issue to accused number 4, 10, and 11 to be present and to attend court on the date of plea. And number 3, I have noted that they have been out, not in custody, and are not brought under any warrants. Each of them who are present before the court will execute personal bonds of Kenya shillings 200,000 shillings with an undertaking that they must attend court on the date that is fixed for plea. And I said it's 7 days, so we are taking plea on 21st of November. These are the orders of the courts.
from International Justice Mission, IJM. We represent the family of baby Pendo, and we are from the victims' legal team. With me here is the team from Kenya National Commission for Human Rights. We also have the team from IMLU. We also have representatives from Utuwetu. An application has been made by the prosecution, by the defense, to try and delay the plea. It has also been revealed today that several applications have been made for anticipatory bail in the case. And furthermore, a constitutional petition has also been filed. None of these cases, we have not been filed with any documents in them, and we have opposed on the basis that justice has been denied, or is going to be denied if their application to oppose bail is granted, or not to take plea. The court listened to the arguments and they made a direction, and they have agreed with the victims' team and the counsels, and they have given directions that the defense have to take plea. They have adjourned the case till 21st of November to allow the accused persons who are not present today to be present during the plea. But for now, we are happy with the judgment, or at least the ruling that has been made. Yes. And we are hoping that on 21st, we'll have plea taken, and baby Pendo and the rest of the victims of the extrajudicial killings and police misconduct that happened in 2017 will not have to wait a day longer for this case to proceed and for them to see justice. I'll invite my senior, Mr. Victor Kamau from Kenya National Commission of Human Rights, to give us some words on.
We have indeed today been experiencing a novel case, which is the first case to be brought under the International Crimes Act, number 16 of 2008. This case relates, as you all know, to the atrocities committed after the 2017 elections. So they are elections related, and they are a very great progress that we are seeing perpetrators of those acts who are actually now security agents being brought to book. This is something we've been really trying for a long time, even in other cases, because the prosecution or perpetrator accountability is an extremely important part of closure for the victims, that those who caused their misfortunes should actually be brought to account. And this is something that we hope will happen much more. There are very, very many other cases, and we hope to see this trend happening much, much more. We are very happy with what the court has said. We look forward to coming back on 21st and definitely commencing these proceedings. We shall be representing the survivors of these horrors to the end. So we are delighted with the court's ruling. Thank you.
With what we've seen today in court, today yet again, and to express dissent, we are impressed indeed as victim counsel, because here is a time for victims to actively participate in prosecution and not just to be passive, as we have seen before. Like I said, with my senior counsels here, we will be happy to appear in court on 21st and to ensure that the criminal process continues for the victims and the survivors, especially of those ones who suffer police excesses during electioneering periods. Thank you.